to part 3 of our presentation, which is Steve Wagner, firm of Wagner and Burkow, talking about sort of general issues that transcend stockholders' directors.
Thank you. I am supposed to be filling in the gaps, and there's been a lot of discussion, and there aren't that many gaps. So what I'm going to do is I'm going to try to give you an idea of sort of the headlines for board meetings and for annual meetings, so that when things come up, you have a framework within which to decide what the correct answer is without necessarily having to memorize all of the rules. Many of them will make sense to you, but how many of you know what a fiduciary is? Somebody tell me, what do you think a fiduciary is?
It's a duty to represent someone in their best interest.
Okay, someone who is appointed or elected to represent somebody else in their best interest. Who else? Go ahead. A person of trust, that's right. Anyone else? Huh?
It's the punctilio of an honor the most sacred.
Okay, a punctilia of honor, most sacred. The simplest definition of a fiduciary, and this is from the Court of Appeals of New York, is one who holds property for another. And that's what board members do. They are trusted to a punctilia of honor and holding basically the assets of the corporation or the condominium for the other shareholders or unit owners. They have a fiduciary duty. Who knows what that is? I'll make it easy. When you hold property for another, you are required to do things in good faith. You are required to do them within the scope of your authority, i.e., what the bylaws, what the declaration of condominium, what their certificate of incorporation allows. And you have to do things in accordance with the law. So now you have board members. Headline is, you're holding property for another. Subheading is, you got to be operating in good faith within the parameters of the bylaws and without breaking the law. So you can't authorize somebody to go beat up somebody or, to knock on the door and say, hey, you got to pay the rent, That doesn't work. You have to follow a process. For example, when you're voting, or you hold a meeting, you have to call the meeting in accordance with the bylaws. Special meetings typically require 2 days' notice, and you have to send the notice the way it says in the law and in the bylaws. For example, good faith, best interest of the corporation or condominium. You can't be lining your pockets. I mean, these are very basic things you all know. But I'm sure you see board members who occasionally violate them. I mean, the guy who has who's the president of a tall building with the marathon running by suddenly winds up with, CBS News or whatever it is, jackets, and now there's a camera on the roof. Zero tolerance on that. Is it okay to have some refreshments at the meeting? Well, I don't think anybody's going to complain about that, but technically, I wouldn't object to that. But anything that really puts something special in their pockets, a jacket, whatever. Now, I had, unfortunately, a client who had a president who was actually, it wasn't a client. Let me correct that. I had a building where the president his wife would walk up and down the streets barking orders at all of the doormen. It was 5 buildings, saying, I want this cleaned up and I want this. And the president of this board was 9 months in arrears on maintenance, but he was redoing his apartment. In fact, he had purchased a second apartment and was combining the two. Red flags are going up. All right? Why? Well, obviously, it seemed to me that money was going south, right? I mean, these are no great big things to figure out. But this guy controlled the board. So, you know, he got away with it for a while until the shareholders finally got news of it. So now, okay, so we're in the board, and we have this problem coming up over and over, and one of the board members says, hey, I want to go out with this. I don't want to sit quietly and watch this go on. Or let's say somebody comes on the board, all right? And the first thing that happens is the board says, you know, traditionally, we have a confidentiality policy, and we'd like you to sign the confidentiality policy. Hell no. You have to know what's in. You can talk about and can't talk about. I wouldn't allow my client to sign a confidentiality because in the example I just gave you, they have to go out to the shareholders. It's probably their fiduciary duty to blow the horn on this. I've had this happen actually in 3 different co-ops and condominium where people have been asked to sign confidentiality agreements. And that actually may be in violation of the fiduciary duty. I know I've been accused of being the tenants guy, and I'll tell you also that my practice started with me representing tenants in buildings going co-op and condo in the late 70s and 80s until the market crashed in 87. And then the buildings, when they got rid of the sponsor attorneys, hired me because I was already familiar with them. But my point of view is different. How many of you have heard the words, we want transparency? Anybody ever hear that before? All right? Sure, you know, you don't have to, under the law, show them the minutes of every board meeting. You're showing them to the attorneys who come in who have either no relationship to the co-op or condo, and or possibly have some relationship in that they want to represent somebody to sue the co-op or condo, but you won't let the shareholders see it. Now, under law, you're not required to, except in certain instances. You don't have to show minutes. It's not required by the Business Corporation Law, except there's case law that says if somebody is complaining about a breach of fiduciary duty, waste, mismanagement, somebody's lining their pockets, and they go to court, the court will let them look at those minutes. And the interesting thing is if they go to court and allege there's been waste or mismanagement, the court does not require somebody to prove waste or mismanagement in order to get to look at the bylaws to be able to prove waste or mismanagement. The court's actually figured that out. But, so do you show them the minutes? Absolutely. Somebody wants to see the minutes, let them come in during business hours. You know, sometimes the law doesn't exactly get it right. And if you're letting people outside, transparency. No, you know, somebody will stand up in the back of that meeting and say, I wanted to see the minutes. You wouldn't let me see the minutes. You work for me. That's wrong. You work for me, and I want to see those minutes. Let them see the minutes. It's like, you know, I try to tell my clients who are co-ops and condo boards, try to get to yes. Don't try to get to no. What are you hiding? You know, it'll come back and bite you at the annual meeting. It'll come back and bite you everywhere you go, at the elections particularly. And if you're the managing agent and you're the one preventing people, when that board's taken over, you know, sayonara, baby. They're going to be blaming you because you're the ones who are not letting it. I encourage a sunshine rule. It's very safe. And it's, I think, the proper position of a board. What are the hot issues at annual meetings? When do you know you're going to have a really tough meeting? Anybody? What is the worst situation at an annual meeting? What gets people riled up? Anyone? Increases in maintenance is number 1 on the list. Number 2? Ron?
I always get concerned when I see the Committee of Concerned Shareholders. That letter
What's that? All right, so Ron is saying that he gets concerned when he sees the committee of concerned shareholders. I'll tell you the other, okay, go ahead. Right. Well, that's the increase in the maintenance, or, you know, but I agree, that goes right in with it. Raising maintenance without, go ahead.
If you can repeat the question and, okay.
Oh, he said major capital improvements. I'm sorry for the camera. Major capital improvements, which would also be an increase in maintenance. Go ahead, sir. Corruption by directors, right. That's interesting, but, and that's the committee Ron was talking about. That's true too. That goes to, by the way, lack of transparency. That usually is stemmed by openness. I find the three hot issues in my practice that, believe it or not, are most likely to result in litigation or challenges to the board are increase in maintenance charges without a clear explanation, or capital, assessments without a clear explanation. And I have found that shareholders or unit owners will tolerate large increases if there's a clear explanation. I represent 2 Fifth Avenue, $30 million assessment to resurface the entire building. Southgate Owners Corp, $9 million for a series of capital projects. They were offered payouts. Nobody took them. When the explanation, a clear explanation was given, people agreed. The other two hot issues I find, and you always know you're going to have a tough meeting, redecorating the lobby or hallways, right? Everybody's going, yeah, that's a big one, right? And also change that pet policy. Keep in mind, dogs are people too, and they live with their families, right? I'm barking up the right tree here. I believe me, after 37, 38 years, I don't think there's anybody who would disagree. So you know that if this is coming up, you better be ready. So how do you, all right, so now you have the annual meeting, and you're going to change, you're going to change the dog policy, have an increase in maintenance charges, and redo the lobby, all right? And there are 3 committees now, and so how do you do it? Well, here's what I do. And occasionally what happens is the president's going to do the board meeting, right? Our annual meeting, and then they say, Steve, you do it. And I'm given about this much time, okay? Good evening, ladies and gentlemen. This is the fill-in-the-blank annual meeting of ABC Property Corp. My name is Steve Wagner. I am the attorney for the cooperative. And I'd like to just set up a few basic rules for this evening. I know we have a lot of important things on the agenda. We have an election. We have an increase in maintenance. We have a dog policy, and we're going to redo the lobbies, okay? So what I say is there's an agenda. We're going to be following the agenda. If any of you don't have it, there's one at the front desk. Please pass them out, right? And also, I'm going to ask that all of you address any questions to the chair, which I will be serving at tonight. If you have any comments, please raise your hand. Please, no cross-talking. And I promise all of you that we will stay here as late as necessary. I'm lying, of course, but as late as necessary to have everyone ask their questions and have the answers given. And the way I do it is I'll start on this side, I'll sweep over to this side, I will sweep back, and we'll just keep on going back and forth until everybody has their question answered. But I also ask that if I ask you to hold off on something because it's out of order, that you please listen to me, and I promise you'll get a chance to ask your question or give your comment. Is everybody okay with that? Yeah, we're okay with that. Okay, now you're set. That's how you start it. And what happens is during the course of the evening, when you get the people starting to yell at each other, and they will, please, cross-talking, let's be civil. We're all grown-ups here. We've been doing very well up to right now. Can we please continue this way? Please address the questions to me. I promised you and you promised me, each of you will have a chance to ask your question or comment. You have no idea how powerful that is if you get everybody's agreement. It's so simple, it's practical. It's going to happen that the president chickens out at the last minute and one of you are going to have to stand up. I strongly recommend that you establish the ground rules at the beginning. Okay? Let's see what else I had here. Contested ballots at meetings. You know, everybody's hanging around the desk waiting for somebody to say anything wrong that they can explode and create a scene on. That never happened, right? Well, first of all, I don't like everybody standing around the desk. You have to give the people, you guys typically, a chance to count the ballots if you are the inspectors of election. But more importantly, if there is a legitimate question about a proxy or a ballot, and it's erupting into a rumble, my recommendation is that you put that ballot on the side, or that proxy on the side. Don't try to make a decision that's going to get everybody upset. You may never have to make a decision. If, at the end of counting all the ballots, other than the ones on the side, the election goes a certain way, and that ballot would not make a difference in the ultimate outcome, you don't have to count it. You don't have to make a decision. The courts, even if somebody went to court and tried to challenge it, the courts want to see if the contested ballots would make a difference in the ultimate outcome. So be smart. Don't try to start a rumble. It's like that TV commercial, you know. Don't do this. Was it the cable TV? Don't do this. You'll be in trouble and you'll wind up in the street. Well, don't do it. You can put it on the side. And then, if you have to make a decision at the end, that's when you call the attorney, because then you can blame him, right? And by the way, that's what we're here for. You know, to make it easier for you, to take the blame for making a legal decision, you shouldn't put yourself in harm's way. I remember many years ago, I represented a 2,700 unit co-op in Williamsburg, before Williamsburg was what it was today. And at the annual meeting or even at board meetings, they had to put a guard on my car to make sure it didn't get trashed. And I took my boss's car. So everybody was happy. Okay? Let's see what I got here. Contested ballots, we did that. Oh, you know, at the beginning, before annual meetings, you start getting a lot of the communications and the committees all start sliding things under the doors. Really good advice is stay out of that. Not as, you know, managers, you would never write something and say the other guy to shut up and he's a, you know, I've had people, you can't believe what people said. I'm sure you can actually. People have been accused of being Nazis. People have been accused of pocketing everything, you know, no basis at all. And everybody now wants to sue everybody for defamation. Okay, stay out of it. What happens, there was one meeting I had many years ago where something very interesting happened. One of the shareholders in the middle of the meeting got up and he said, you know, pox on all of you guys. That's not exactly what he said. And he said, I come home at night. I don't want you slipping things under my door, accusing the other guy of doing this and doing that. You can all go stick it where the sun doesn't shine. And he was right. You get one chance. You get one letter. That's it. Don't do 3 or 4 or 5 or 6 or 7. It's people just they stress out. They don't want to see it anymore. You get one. And make it 3 or 4 bullet points, and maybe even make it a slightly different color. You know, I said like green or pink or something so it sticks out. So in all the crap, they can pick out the one that you have. All right? Don't get involved in going back and forth, and recommend that to your boards. It'll save them a lot of problems later. Let me see what other words of wisdom. Oh, the executive committees is a great idea. Executive session I disagree with. I don't think works because executive session of the board, you can't say this board member, you're out for the executive session, but you can have executive committees. And the executive committees, I had one building where we had somebody who every time something was done in the meeting would either disclose it to the attorney who was already litigating or would tell all the shareholders, you know, something was up. It was just a horror show. And so I suggested that their bylaws have a provision saying executive committee use that. And they formed an executive committee, and they basically ran the building for an entire year without inviting this board member. And this board member rightfully got very upset, and they brought a lawsuit. Oh my God, a lawsuit. You know what we did? Before we answered, we called a meeting. And when we got in front of the judge, you know what he said? They called a meeting. What do you want? Okay? That's what happens. Not a big deal. All right? I don't recommend that you run a building just with executive sessions. Not a good idea. But, if you need to, the penalty is you have to call a meeting. Same with the annual meeting. I mean, there should be annual meetings every year.
That's why they're called annual meetings.
Yeah, yeah, and not, deca-annual meetings. But the penalty for not calling the annual meeting is you have to call a meeting. And you should. I mean, I'm not advocating against it, but I'm giving you guys at least some thoughts on trying to deal with very objectionable, board members. People who memorize Robert's Rules of Order, unless your bylaws, I actually did see a set of bylaws that referenced Robert's Rules of Order, but unless they reference it, the rule is that things have to be done in a parliamentary fashion. I completely agree. Less is more in your minutes. Motion, second, discussion was held, not Harvey said this and Karen said that. Motion, discussion, second, discussion, the result of the vote. I say that if somebody doesn't want to vote in favor of something and really objects, they can, if they want to, have a statement of their objection in the minutes. That's actually Robert's rules, but I don't necessarily think that if you have a crazy person on the board that you need to tell them that, but because Robert's Rules of Orders don't necessarily apply. It has to be parliamentary. Yes.
That's a joke.
Yeah.
You hear that all the time, point of order, point of information. Robert's rules do not apply.
Yes.
I would still answer the question, and just for the embodiment here, presidents can vote at any time. They don't have to just vote
Exactly.
at the time to break the tie. President can vote at any time during the board meeting.
You want to hear something very good, though, Okay, I'm sorry. I'll do one last thing for all of you. A motion to table. Okay? Somebody makes a motion. All right? Second, discussion. Everybody's at each other's throats. Motion to table. Okay? You can make it even while there's something pending, and what you do at that point is you hold an up or down vote on whether to table. There's no discussion on a motion to table. You vote right then and there. You can cut off a long discussion or something that's resulting in a fight, and it's a very effective way to move meetings along. I am sorry I'm taking too long. I was enjoying myself. Thank you for the opportunity.
Thanks, Steve Kirkpatrick. So I'm going to cover litigation issues because that's mostly what I do. And you've heard a lot of great advice on how to conduct director meetings, shareholder meetings. But then the issue is what happens when things go wrong, either when you want to sue one of your residents over an issue or if you get sued. And the key thing whenever you get into a litigation posture is that all of the protocols have to be handled perfectly. You've got to follow the BCL requirements, the bylaws, the proprietary lease, because the main things in these types of litigations are that the courts will look at procedural issues. Did you give the right notice? Did you have if you had a vote by email, that would be set aside. Did you have the right percentage of votes? And these cases very often get decided just on a technical issue, and the court would then set aside whatever either the board did or what was done at a shareholders meeting improperly. Another issue is acting within the scope of authority. There are issues that shareholders have to deal with. There are issues that directors can deal with, and these are all governed by the documents, and in many instances brought by the proprietary lease. For instance, there have been cases where there's a case, the Usin case, where one of the building residents challenged a rule that prohibited dogs that was enacted, and the court set that aside because the proprietary lease had language in it that allowed dogs to be kept in the building. And as a result, since the rules requiring a supermajority shareholder vote to amend the proprietary lease were not followed, the court set aside what had been done at a meeting. One of the issues in litigation that comes up often that I get calls about is, you probably all have heard about the Pullman case, which is where a building shareholders voted to terminate a proprietary lease. And in that instance, the governing documents said it had to be a shareholders vote. The shareholders got good legal advice. They followed to the letter what the protocols were. They gave proper notice. They made sure they had the requisite attendance at the meeting to have a quorum. In this instance, what they did, and that's not typical, they got a court reporter to be present to take detailed notes about what was done. They gave the shareholder at issue, Mr. Pullman, notice of the meeting so he could come and appear and defend himself. And this was all done on the on the record, on the formal record with a court reporter. And as a result, because the building followed to the letter all of the governing requirements, when it went up through the courts upheld what was done. And since it was upheld, the business judgment rule was held to apply. And as a result, the courts would not second guess what the building had done vis-a-vis Mr. Pullman to terminate his lease. So really, when you cut through it, all the court really did was looked at were the proper procedures followed. Once the procedures were followed, what the court did is just affirmed what the building did. In other instances, there's a case, London Terrace against Davis, where under those governing documents, it was not the shareholders that would vote to terminate, but rather the directors. And that's why you really need to, get it right. If they had done a shareholder vote, then the resident could have set that aside, because in those governing documents in the proprietary lease, termination would occur by a director vote, which is, actually simpler. But again, the directors, they gave the right notice. They followed all the requirements to the T. Steve talked about one of the very contentious issues that comes up at meetings, and one of the cases that I handled in the past year or so was a dispute involving an HDFC co-op, which is city supervised, HPD supervised, and it involved how maintenance was set. And in this building, the rules were totally not followed. One of the shareholders got sued in a non-payment case and challenged what was done, and ended up being able to basically derail the case, because this shareholder was able to point out that the way the maintenance was set, even though formal meeting rules may have been followed, the document the proprietary lease, and bylaws were not followed because when the maintenance was set, the proportions were not correct. So, whether it be there, sometimes it's done by the size of the apartment, more typically it's done by the number of shares, but in this building it was not done as required, and the shareholder ended up, basically winning the case, setting aside this attempt to collect rent, and more importantly, in a co-op situation, recovering legal fees, because in a co-op where you have proprietary lease language that gives the building an ability to recover legal fees, the tenant, under statute, under Real Property Law 234, has a reciprocal right. So that's something that you always, when you get into a litigation, you have to consider very carefully, not just the cost of what your legal fees are, but the possibility that if you're suing a tenant, that they would recover their legal fees. And one of the issues comes up if you have a troublesome shareholder, troublesome person in the building, and this is somebody who sues, who likes to sue. One of the things that you would want to look at is how can you recover your legal fees? And very often, most leases, in that instance where a shareholder sues the building, there would be no recovery of legal fees, even if it was, a suit that got thrown out as being without merit, because typically proprietary leases require a default to recover legal fees. And when a tenant sues a building, it's not really a default, but rather a determination of some issue, and the courts have held no legal fees. So, it's important to understand what your documents are, and in that instance, if you want to be able to recover legal fees, to amend your proprietary lease and have a provision in that proprietary lease that says that legal fees are recoverable, both in the prosecution of a default litigation or in the successful defense of any litigation. And if the lease has that language, then the building would recover legal fees from that problematic shareholder. Going back to one of the issues that was covered earlier, minutes, communications, you have to remember that in a litigation, everything is discoverable. There are times that what I will recommend to a board, if there is some very sensitive topic that's being discussed, it may make sense to have an attorney present at the meeting, because you've probably all heard of attorney-client privilege, and that's where you talk to your lawyer, you ask for legal advice, you get legal advice, and there are instances where some sensitive issue was being discussed. What I've told the client is let a lawyer come to the meeting. If a lawyer comes to the meeting and there's a discussion about claims, defenses, legal issues, and advice is asked for and given, then everything that went on is then covered by the attorney-client privilege and would not be discoverable. It's an absolute privilege that could only be waived by the client, here, the board of directors. Otherwise, you just have to think about what you say, and less is more. And as was said before, the worst thing that you can see is deep from a litigation standpoint is detailed minutes. This is what he said, this is what she said, verbatim, because all of those things, people don't understand that, how things play out in the litigation. They say things that turn out to be, when, sometimes taken out of context, can be really devastating. And where documents say more than they should, another option is redaction. If somebody requests documents, there's some sensitive information, some personal information, it's perfectly proper to redact the information and provide a redacted document.
Steve, let me ask you one thing. What do you think of emails between you and board members that say attorney-client work product, privilege and confidential communication?
What I find is people, you have to really understand what attorney-client privilege is. And attorney-client privilege is either an attorney giving legal advice or somebody asking for legal advice. But it's not, if just because an email says attorney-client privileged, confidential, it doesn't mean that it is. That's really a flag to look at. Geez, but it may still not be privileged. I mean, there are times that lawyers get involved with discussing business issues. That's likely not going to be privileged. So you really have to be careful. Don't be overconfident that something is going to be privileged.
Okay. And please, the questions from the panel, if you could talk into the microphone, because we're hardwired into the video.
Sorry. So I think everybody hopefully got the sort of the gist of that, but if there are any other questions, we'll speak into the mic. Some other issues that I have litigated had a case involving a challenge of an election with a director, and basically I represented somebody who wanted to become a director, was not voted in, and what we did is we were able to go through the procedures that were followed at the annual meeting and learned that the technical requirements under the BCL, under the bylaws for the election were not followed, and as a result, we're able to go into court and and have the result set aside. And what that did is, as a practical matter, it sort of chilled and it chilled the building, and our person was able to get in. So it's just it emphasizes the importance of following the protocols, because if you do something wrong and it's challenged, court's just a very easy way for a court to get to a result, because either it was done right, it was done wrong, and if it was done wrong, it simply gets undone. I have a case now. I've actually had, in the past few years, a couple of cases dealing with decorating issues in my cases on floors, public areas of high-end buildings. And the first case involved fiduciary duty, and I represented one of the unit owners, and our claim was basically that the other unit owner, who was very, very wealthy, was able to improperly influence the board, and it ended up getting resolved out of court. But we were able to prevail by being able to show that the board was not following its fiduciary duty, because they were giving this other shareholder excessive say in how this public hallway was going to be decorated. In another case, similar issue, dispute, the strategy was that the building would amend the house rules, which were at issue, and basically resolve the dispute by letting the board come in and dictate how the decorating was going to occur. And in that matter, what became the key litigation issue is, were the protocols followed? Did the board meeting have the right notice? And did you have the right majority vote? And one of the issues was interested directors. What happens? And what had done here, because the building knew this was going to be the subject of a litigation, is that the interested director recused himself and was didn't take any part, so they still had the requisite vote to follow the right procedure. Uninterested directors, it's, recusal is, if you recuse, you're always generally safe, but it's not technically required under a lot of case law. If you have simply a full disclosure and the other directors know about your interest, that's enough.